The chair recognizes the Attorney General from constituency number 9. You have the floor.
Thank you, Madam Acting Speaker. I stand today to respond to the statement made last Friday evening during the motion to adjourn by the Honourable and Learned Member for Constituency 31, Sean Crockwell. In his statement, MP Crockwell has incorrectly stated that by letter to him I had instructed that neither MP Pettingill, MP Crockwell, nor any member of their firm could represent any client against the government. This statement by the Honourable and Learned Member is incorrect. First of all, let me confirm that I did send a letter dated 3rd of June 2016 to MP Crockwell. That letter arose from correspondence between a client of his and the Bermuda Police Service in respect of a dispute. I will not go into any more detail than that out of respect for the interests of his client, although I take the view that MP Crockwell has waived any legal privilege by raising the matter in public. Second, I did object to MP Crockwell and Pettingill and Company representing that particular client in that particular matter. The reason for this is because various aspects of the dispute were connected to a contractual matter, features of which were subject to advice by the Attorney General and came before Cabinet for decision on 2 separate occasions during the course of 2013, when the Honourable and Learned Member for Constituency 25, Mark Pettingill, was serving as Attorney General. Counsel in chambers raised concerns with me that there was a material conflict of interest with MP Crockwell representing that particular client in that particular matter. In my 3rd of June letter, I sought to inform MP Crockwell that as a result of him acting for his client in this matter, there was a potential breach of the Barristers' Code of Professional Conduct. With your permission, Madam Deputy Speaker, let me read Rule 24A of the Code, which I quoted in my letter and which all members of the bar must comply with.
Please proceed.
Where a barrister or a member of his staff who has acted on behalf of a client in a matter, irrespective of the nature of the matter, subsequently joins another firm, the new firm, which acts or has the opportunity for acting or acting for a party with interests adverse to those of the former client, he or that staff member and the new firm should cease or decline to act in the matter if he or the staff member is by virtue of his former capacity in possession of material information which would not properly have become available to him in his new capacity, provided that the Bar Council may, after ascertaining the views of the former client, exempt a barrister or a member of his staff from the above requirement. Close quotes. MP Pettingill served as Attorney General from late 2012 through to mid-2014. The government of Bermuda was his client then. His present firm, which includes MP Crockwell, now represents a client in a dispute against the government. The foundations of this dispute touch upon a contract which made its way through the Attorney General's chambers, partly during MP Pettingill's tenure as AG. Cabinet made 2 separate decisions of that in respect of that contract, with MP Pettingill participating as Minister of Legal Affairs and Attorney General, and MP Crockwell participating as a minister. In my opinion, there is a reasonable perception of a conflict of interest. Madam Deputy Speaker, Rule 24A of the Bar Code of Professional Conduct states that this prohibition against acting for a client applies where lawyers have access to information they would not otherwise have had were it not for their former capacities. If the client in question had hired someone other than MPs Pettingill or Crockwell, they would not possess the knowledge and information of 2 former cabinet ministers, one of which was government's principal legal advisor. Madam Acting Speaker, there is nothing untoward or surprising about this rule and about its application in the present case. The Code of Professional Conduct applies each and every time a lawyer leaves one firm to join another. You will often see law firms having to give up files for this exact reason. And government is as much a client as anyone else and should be entitled to the same level of protection afforded to any other private person. What is interesting, Madam Deputy Speaker, is that Rule 24A of the Bar Code of Conduct has a proviso which states very clearly that MPs Pettingill and Crockwell could apply to the Bar Council for an exemption from the requirement. And might I say, Madam Acting Speaker, the Bar Council...
Member, you cannot deviate from your statement.
That's fine. I wrote MP Crockwell in the following terms in my 3rd of June 2016 letter. I said, open quotes, "As a result of the above, I invite you, your firm and anyone working for your firm, to remove yourselves from this matter and to avoid representing either this client or any other person against the government in future, so that any potential conflict of interest, any potential breaches of the code can be avoided." I politely invited MP Crockwell to take this course of action to avoid the perception of anything untoward. This cannot be said to be an instruction or intimidation. This letter was not the end of the matter. MP Crockwell wrote back to me on 7th of June 2016 and took issue with my invocation of Rule 24A of the Bar Code. He also stated that his firm, open quotes, have instructed Queen's Counsel to thoroughly address this issue with a view to sending you his legal opinion in due course. At the time, I appreciated and accepted this professional courtesy. I was therefore more than surprised when MP Crockwell made his statement in the House last Friday. I have not received a copy of the QC's opinion, which was promised to me. Thank you, Madam Deputy Speaker, for the opportunity to state the facts, and we still look forward to resolving this matter.